Well, let's get some reactions. We're joined via Zoom by Advocate Stefanie Fick, Executive Director of the Accountability Division of an organisation undoing tax abuse. A very good afternoon to you, Advocate Fick. Thank you for your time with us here on the SABC.
Good afternoon. Thank you, Liesl. Always a pleasure.
Right, let's get into the matter at hand. The Constitutional Court having found that there was a rational reason for President Cyril Ramaphosa's decision to precautionary suspend the Public Protector, Advocate Busisiwe Mkhwebane. Let's get your reaction on the matter.
I think it's a good decision. I think what is happening is that, it becomes a whole political issue, but we need to stay back and just realize that, whether the suspended public protector is in a position, is fit for office, is currently the subject of a Section 194 inquiry in Parliament. Before that, there was already an independent report that stated, for example, that she is wrongly applying the law and, there's incompetence and failure to take relevant facts into account. So there were really, nasty findings against her. And if you also take into account that the ConCourt, even in this judgment, recognized the fact that they made grave, judgments against the public protector, then you need to ask yourself, objectively, does she have to be suspended? And I think the answer is yes. Not only for her to be enable her to prepare for the 194 inquiry, but also to protect the integrity of the public protector's office.
Let's get into that just a little later on. I think based on what you've just echoed now, I wonder what the way forward is for the public protector, given that this judgment had been handed down by the apex court of the land.
Yeah, so there's nowhere for her to go. She will remain suspended. Plus, for example, found that there's no, what is the detriment to the public protector? I mean, she's suspended with full pay. If you ask me, I think her, just the prima facie incompetence and etc., that she should have been suspended without pay. But be that as it may, yeah, there's basically no wiggle room for her. Although we've seen previously, unfortunately, how certain litigants can use the law and just waste time and try something new and something that hasn't been done in our law. So hopefully the public protector or the suspended public protector will take what the ConCourt has set into account and just leave it there. Let's finish the Section 194 inquiry in Parliament.
So perhaps I can go back to your earlier point about the effect that this has had on the Chapter 9 institution. Perhaps also what it is going to have going forward, particularly as we are also witnessing, the process to appoint a new public protector at large as well.
Yeah, I do think if you have someone that has been, there's really some scathing judgments against her. She was, the head of a very important Chapter 9 institution. The public protector is basically there to look after the, just normal people against the machinery of the state. So her integrity, not only as an advocate, who is an officer of court, but also as, the main person in the public protector's office, it is extremely important that the integrity is upheld. And that if you just think on the balance, that it is better for her to be suspended so that the public protector's office can go ahead with their work, which include all the investigations. We now know that it was finalized, but, include investigations against the president and everybody else so that they can continue with that work without her present.